Tammy Wallace. I'm the co-founder and board chair for the Greater Houston LGBT Chamber of Commerce. I want to thank Waterman Steele for sponsoring the webinar today. Waterman Steele has been a tremendous executive level partner with the Chamber. And Lance and Elizabeth, we're glad to have you. I'm going to introduce them shortly. I want to also welcome, I see a lot of our members on the call, but also a lot of guests. So we are very glad to have you here with us today. As I'm sure most of you have done over the last 25 or 30 days, we have changed our business as usual, moving everything to webinars, an online format. So we are adapting to this new format, but we're pleased to be able to bring important topics like the one today regarding commercial leases, because we think that is so important. We'll continue to do that. I do want to encourage you to visit our website. We do have a COVID-19 resource page set up for business owners. We continue to update that as new information comes out. You can find that on our website at HoustonLGBTChamber.com. A little housekeeping. So today, I have a feeling there are going to be quite a few questions. So we're going to ask you to include those in the chat. And then both Maureen and I will be monitoring those, and we will share those with Lance and Elizabeth as they come in. Or towards the end when we'll have some Q&A as well. If it's very relevant, we'll pipe in and ask them that question. That being said, let me not delay any further. I do want to introduce our speakers. And again, Lance and Elizabeth, we're very, very appreciative to have you here today. And this is such an important topic and to bring your expertise. So let me first introduce Lance. And Lance and I started talking about this really right after COVID hit, about potentially doing this, and he has been tremendous help with some of our members, and we appreciate that. But I think you'll see with both his and Elizabeth's background why we have them on the webinar today. So starting with Lance, he spent most of his career focused on retail user transactions, including tenant representation and project development. He has represented national, regional, and local restaurateurs and retailers throughout a broad market area, including Texas, Arkansas, Louisiana, Oklahoma, and most of the southeastern and western United States. Lance's clients have included local, regional, national firms such as Aldi, Amagi Bank, Bally's Total Fitness, Cabela's, Circuit City, just to name a few. He also represents or has represented national and Houston local restaurateurs as well. He's a partner in Waterman Steele Real Estate Advisors, a member of the Waterman Steele Group, and until 2013, he was the managing partner and shareholder in UCR Houston and its predecessors, Moody Ramon Interests Retail Properties Division, which he co-founded in 1993. Elizabeth Pringle Johnson. Elizabeth is a partner with the law firm of Hansen Laporte. She specializes in tenant representation in commercial leases, commercial real estate secured lending, commercial real estate development, and general business transactions. She is a native of Mobile, Alabama. She has resided in Houston since 1982. She was a partner at Winstead Firm prior to becoming the general counsel and senior vice president at Camden Property Trust. She graduated from the University of Alabama at the top 5% of her law school class and was selected for the Alabama Law Review. She has served on the boards of West University Elementary School, Lanier Middle School, and St. Agnes Academy. She was president of the Heart of Texas chapter on the National Charity League and has volunteered extensively at Medical Bridges, Christian Community Service Center, and Memorial Hermann Hospital. How timely to have you both with us. Lance and Elizabeth, again, thank you, and I'll turn it over to you.
Well, and let me thank Elizabeth for joining us. As y'all may know, I'm not an attorney. We oftentimes walk the fine line of practicing law as real estate advisors, but we always partner with great attorneys, and Elizabeth is one of our firm's great collaborators, and she and I have represented several clients together, and she has partnered with other members of our firm to represent clients. So I know I trust her advice implicitly for our clients, and hopefully she does the same. But I would just introduce this, and we have a PowerPoint presentation, Maureen, that if you can put up on the screen, I would appreciate. That is really intended to kind of just organize our thoughts. Elizabeth and I both recognize the majority of the conversation today will be in the form of questions, because each one of your circumstances is unique. This is a unique time for us too. We're simply applying skills that we've acquired over the last 20 or 30, or in my case, 40 years, engaging with landlords and on behalf of tenants in an environment that is remarkably different and takes every bit of patience we've ever had and understanding on both sides of the transaction. So what we thought we would do first is, if you do the next slide, please, Maureen, is walk through a series of questions, and Elizabeth and I are going to probably end up stepping on each other a little bit and going back and forth to interrupt each other. Go through a series of questions that we want you to think about, and then we're going to ask you to respond to those questions. This format allows for some polling so that not only have you thought about your particular circumstance, but Elizabeth and I can learn a little bit about who's on the call and what your specific needs are. So Elizabeth, are you cool if I just kind of walk through these slides at this point?
Oh, that's a good idea, yeah.
So again, we've got folks on the call, who are in different circumstances. What type of space do you lease? Are you in an office building? Or are you in a retail shopping center? Or are you in an industrial service center or some other kind of warehouse? Or are you in a unique type of space that may be different? Are you in a single tenant building or a multi-tenant building? That is, do you have, in our building where we office, we're in a kind of a non-traditional building, but we still have other tenants that share the entire building with us. And oftentimes leases will be different based on what type of environment you're in. And then the other one, and it's a contextual question, but is how long you currently occupy the space. And as we go through some of the feedback from you, that'll give us some indication of what those expectations of relationship and trust with your existing landlord have been. And in some cases, even though you may have been a tenant in the same building for 5 or 10 years, the landlord may have changed 2 or 3 times. So it may not necessarily apply to every situation. Next slide, please. This is more to our curiosity, is we would like to know, just as we engage with you today, and again, these are anonymous responses, but did you have a broker represent you when you leased your space? And did you have an attorney review your lease prior to its execution? Obviously, given what Elizabeth and I do for a living, we're big fans of whether it's our firm or another firm, engaging on your behalf as your advocate. Not everybody's a real estate expert, and certainly neither one of us know how to operate your businesses either. Next slide. This is an important question that we'll talk about today. And again, we wanted to get feedback from you. And the reason I'm walking through the questions is so you'll understand why we're asking. And again, the responses will be anonymous. Is, did you personally guarantee your lease? It's an important question to us as we engage on behalf of a tenant, whether it's in the beginning of a lease, which is always our first choice, or in the middle of a lease, which is where most of you are right now. Is who's the actual tenant? Do you have a LLC or an LP that you set up that is the tenant? And if you have an LLC and LP, because that LLC or LP may have been a new entity, did the landlord require you to personally guarantee the lease? As you engage with landlords, especially in a time of stress, it's important to know who the landlord's legally dealing with and who's legally responsible for the obligations of the tenant. Next slide.
Lance, let me add one thing to that. I'm not sure how the polling, what kind of options it gives you, but on your personal guarantee, if there's a limitation on the guarantee, if you could note that, just say it's a partial guarantee if you have that option, because that's a very important point in what we're going to talk about.
Yeah, and the poll, actually, that's a great question, Elizabeth, and the poll doesn't address that. I can't remember exactly how I wrote the question, but it's very important. Elizabeth's right. It's one of the things that we try and do on behalf of our clients. And in many cases, in fact, most cases where we have a single asset entity as the actual tenant, is our client or another entity owned by our client, owned or controlled by our client, will be the guarantor. And we've always endeavored to, when those guarantees arise, to have the guarantee not be a unconditional broad guarantee of all obligations, for it to be more limited or defined. And again, these are those conversations that I've always said to friends is, prenups in a marriage are important, but when somebody pulls out the prenup and starts reading it, you got a problem. Same thing with the lease, is leases are important, but when everybody starts pulling out their leases and reading them, you've got a problem, and you find out what you agreed to back then may not be what you wish you had today. And then the last question in this poll, and we'll pop it up after this, is do current government restrictions make it impossible for you to operate your business as envisioned? And those words are kind of nuanced. Impossible is literally you can't do it. And envisioned is, you could substitute a number of different words in there, as you're obligated to. Your lease may read a little bit differently, but I'm curious, and I think Elizabeth is too, is because of orders by our county judge or our mayor or others in the state, is your business not operating today as you planned it to operate in order to be profitable? And that's an important thing that Elizabeth will talk about as we go through this conversation today. So, Maureen, you want to go to the next slide and just pop up that we want to, I guess, put up the poll right now if you can. Yeah, go ahead and just put up the poll if you don't mind, Maureen. And so there's going to be 3 sets of questions, each with about 3 questions. If you can just answer those, it would be great. And we'll take just a couple of minutes to do this. So, what type of space are you leasing? Office, retail, industrial, or other? Are you in a single tenant building or multi-tenant building? And then how long have you been in your current space? And I'm going to go ahead and even answer for us just for grins, because it'll throw it off if we don't. There'll be somebody struggling.
Do I need to do it too, Lance?
You don't have to do it, Elizabeth. It just won't
Okay.
show up in the response. I like doing it because I like filling out forms. Maureen, why don't you kind of let us know when you've got the majority of the responses or all the responses, and then we can put up the responses if you can display the responses. Okay. Yeah, so this is kind of as we expected. Okay, great. So the majority of the folks on the phone today are in office, and then a few in retail. And then as we go into the questions, whoever responded other, we can certainly talk about that as needed. Okay, so this is great information. All right, do you mind putting up the second poll, Maureen? And I'll trust you, Maureen, just to put up the results when we get there. Well, the one great response here is, and I actually added I do not recall, but will for sure under the guarantee, as that's an expected answer. Is it's funny what you don't remember what you did until you have to find out if it's important. But there's actually fewer of you that guaranteed your lease than I thought there would be. So that's
good.
That's good. Yeah, and from Elizabeth, and I should ask the question: if you didn't have a broker represent you, did the attorney represent you, or vice versa? Ideally, in our firm, we collaborate with attorneys. We're not legal counsel, and so we always make sure that we have either someone like Elizabeth watching over our shoulder or at the table with us. Okay, and then the last question, if you don't mind, Maureen. And I'm looking at the questions I'm asking guys, and this is written poorly. There actually should be, because I realized in me trying to answer my own question is my firm, for example, we're operating. I'm here in my office today. We're not operating like we envisioned. So I guess I'm a yes, sort of, but my business certainly has not been impaired like a restaurant's would. So I probably should have provided another response for that. I apologize. It's not.
For purposes of what we're talking about today, I think from a force majeure question, it really is whether or not you're considered an essential service. Just like a restaurant has to be shut, so there's a force majeure issue there that's not going to be applicable to, for example, your situation or my situation.
Okay.
Your business is down, but you're not prohibited from operating.
Right. Okay. That's interesting too. So it may be some different conversations for different people, because the essential service, what we've seen is some of the essential services I heard a quote last night on TV is, I'd rather have no business for a month than have a reduction in my business by 20% for 6 months. So that, okay, well that helps us and maybe gives everybody appreciation for the circumstance you're in and that you're not alone. Start talking, Elizabeth, I'm going to encourage you to jump in on top of me, but the again, concept here too is, as a real estate broker, sometimes landlords will tell you, this is our standard form, or this is the form everybody uses. And there are, in fact, promulgated forms that are available from the state Texas Bar, I think, Texas Real Estate Commission, and those can be printed or promulgated forms, but there is no standard lease form. There is I'm going to guess everyone on the phone today or in this Zoom has a different lease, and that oftentimes that leases for office and retail industrial space will all contain unique provisions that are unique to those environments. When it goes to shared services, for example, in an office building, or to common area maintenance in a retail building, or hours of operation for retail space. And then again, it sounds like we've got at least one or more on the call today who are in a single tenant building, which again, sometimes those leases are the simplest. They can also sometimes be the most burdensome in terms of responsibilities. So Elizabeth, anything special we want to mention here?
Well, one difference I would point out with a single tenant building is that you are more uniquely in a position to lower your common operating maintenance costs. So your common area maintenance costs, because you can just shut down your building. And that could be a cost savings that somebody in a multi-tenant building is not going to be able to enjoy, and could be something that you could talk to your landlord about. I don't want to get ahead of ourselves here, but you just have some different options if you're the only tenant.
Your next slide, Maureen, if you don't mind. Try not to be bossy with Maureen here. So this is a concept that actually Elizabeth and I talked about, because when I wrote these slides, is she asked, I think we had to have some conversations about what does this mean, and I think today is the environment we're operating in today is the perfect time for this conversation. Is you will sometimes hear, and one of your members had very impressively and thoughtfully read their lease early in this pandemic and early in the impacts. And I had a conversation with them as to, my business is closed. I've had to close my business. I can't operate my business, and my lease requires me to continuously operate and occupy the space. And should I not do that, then it's considered abandoned. And if that happens, I go into default. And if I go into default, the landlord has the rights to sue me. And that arguably someone would say is a closing of your business is a non-monetary provision. My attitude is there are no non-monetary provisions in your lease, because the way that your member was reading their lease was exactly correct. And that closing your business, abandonment's a legal concept that Elizabeth can discuss more than I can, but closing your business can become an event of default. And if you go into default, the landlord has rights to accelerate in many cases and go after you. And although the members' perspective on that had great foresight because their rent wasn't even due for another couple of weeks, they were worried about it. And I think, and this is a particular time where you need to make sure you read your entire lease, because everything in your lease is about the money. And that's what landlords are focused on right now, is they're being able to pay their bills. And again, as we talked about in the prior slide, is your individual leases will contain individual provisions, and you need to read those leases very, very carefully to see how these current circumstances cause your lease to have unique impacts upon your business. Elizabeth, I know you maybe have some expanded thoughts on this one.
Right. So the operating covenant is an excellent example right now, obviously, and we'll get to this a little bit in a minute, but there's a concept of force majeure, which prevents you from fulfilling the terms of your lease right now. And a pandemic is clearly the force majeure. The government has said you have to stay inside, you can't go and operate your business. That does not apply to paying your rent, but it will certainly apply to most of the non-monetary obligations in your lease until things change significantly. So while you need to be very aware of those covenants and you need to be prepared to resume performing under them as circumstances change, those are the kind of things that, and I'll make an overall statement here. While you are quote unquote adversarial to your landlord right now, he owns the building and wants you to pay the rent. He also needs you, or he or she. They also need you. They need you to be in business when this is over. So you need to approach all of these questions with, how can this become a win-win for both the tenant and the landlord? Again, a non-monetary default right now does nobody any good. So while you should be aware of them, that's the last thing that you should worry about.
In fact, why don't you go to the next, go on to the next slide, because I think it segues, your comment segues perfectly into that, Elizabeth, is, and this starts going directly into how to engage with your landlord. So I will just share with you anecdotally, I guess it's been now, and again, I can't tell you what day it is today, I can't tell you what day of the week it is, much less what the date is. Basically, except we've worked 7 days a week, as probably you have, because we're all officing in different environments than we were before. But about 3 weeks ago, I told my grown children it was probably the most difficult week of my career, because I am used to, from time to time, having to engage on behalf of a client where we have to mitigate an obligation. We've made a bad deal, something hasn't gone like we wanted it to go. Sales haven't been what we hoped. There's been an unexpected event in a family or an ownership where we've had to go to landlords and work through our leases. 3 weeks ago, I was doing that all day, every day, from about 7 in the morning till about 10 o'clock at night. And in every case, like with your member, is we were addressing that in advance of April 1st rent being due. So gosh, I guess it's, 3 weeks ago, 4 weeks ago. And it was about communication, but we received a number, and we're only now actually starting to receive written responses from landlords, but we were simply calling landlords, particularly for our restaurant clients, and saying, we're not going to be paying April 1st rent. Well, as a courtesy, we just want to give you a heads up that's going to happen. But we in every case initiated the contact. In every case, we documented the contact, and Elizabeth's going to address this in the next slide, is we documented that communication with an email. We are now seeing landlords come back to our clients, and there's a stack of them with different proposals, some to defer rent. You don't have to pay rent in April, May, but we want you to take April, May's rent and then add it on to June and July, which doesn't do anything for anybody, because I think we're going to be always struggling to get back to whatever normal looks like in June and July, and this is going to go for a while. But they've asked, in some cases, landlords have asked for a whole lot of information that typically would go along with a major workout. Well, we want to see financial statements for the last 5 years. We want to know this and that. And the response is, unless I have to provide it in my lease, I'm not going to give you anything more than I legally have to give you, because this call isn't a result of my business changing. It's a result of our world changing. And to try and treat this as if though it is a temporary disruption that is caused by something that my client as a tenant did is just not applicable. And then the last thing I'll say, and I want Elizabeth to jump in on this, is I would ask you to remember not all landlords are created equal. And I say that in that you have an obligation to pay rent. My firm has an obligation to pay rent, and thankfully we've been able to pay rent, and we got a PPP loan that helped defer some of those costs for our people and our rent. But I'm sympathetic, at least, maybe even empathetic to some of the smaller landlords. When you don't pay rent, it directly affects them and their families. And that's all I ask. It doesn't mean you pay rent. It just means to be thoughtful that if you're talking to a large REIT or a institution, or some of you may office downtown and the owner of your building is a multi-billion-dollar company. Others of you may office, and in fact, I know at least one of you office in a small building that is owned by an individual, and he probably has a mortgage. In fact, I'm certain he does, and he's having had these same conversations with his lender. So if you feel that stress in your conversations, just be mindful of it. They may be going some of the same experiences you are. It still doesn't matter. It still doesn't mean you don't exercise your full rights and you don't do what's best for you, but be thoughtful about that. Elizabeth, am I touching on the right things there?
Yes, and I think that's an excellent point, that you need to know who you're negotiating with and where they're coming from and what you can offer to them that, again, will be a win-win for both of you.
Yeah, and to your point, and to your point earlier, is particularly in the retail world, but this is going to be applicable across our entire, and I'm actually more worried about oil prices in Houston than I am COVID-19 right now, long term for landlords. But be mindful, it's in the landlord's best interest to see you be successful. Hopefully this is a relatively short-term event, whether it's 60, 90, or 120 days. And in terms of a multi-year relationship, that's nothing. And for the landlord to become aggressive and do things that are terminally damaging to your business right now, in my opinion, and I've gotten into it with some of my friends, and I'm a landlord, is it doesn't serve anyone well. For us, for the landlord community, when I've said us, I meant it, because like I said, I own some property, is for us to kill tenants is a super bad idea, because there's not going to be a long line of tenants waiting to take your space or my space when this is begins to self-correct. So anyway, and then last slide, and Elizabeth, I'll let you really focus on this one. The next slide, Maureen.
It's up.
Oh, okay, sorry.
The first thing I've already mentioned is that your obligation to pay rent is absolute, and that's just a basic premise of any kind of commercial lease. There's no give and take. The landlord doesn't have to provide any services to you for you to obligate it to pay your rent. And just do a real brief little tutorial on commercial leases, that in the event that the landlord does not perform, while every lease is different, this is universal. Your remedy is to sue the landlord for damages. It's not to not pay your rent. So you can't say, well, the center isn't being operated the same way, the building isn't being operated the same way, so therefore I don't have to pay my rent. That is irrelevant. You pay your rent and then you sue your landlord for damages. And in fact, your ability to collect damages is limited to the landlord's ownership interest in the building. So it's not a very good remedy. So you have to pay your rent. The next part of that, though, is who is obligated to pay the rent. The tenant is obligated to pay the rent. And in most instances, the tenant is not going to be you individually. The tenant is going to be an entity. If it is you individually, it's a different conversation, and you are, unless there's some special provision in your lease that limits your liability, then you're on the hook for all of the rent. If it is an entity and you have a guarantee, you need to be very cognizant of what your guarantee says. And here's why that's important. Many, if not most, guarantees have some kind of a cap or limitation. 3 years, 5 years, $500,000. It could be a dollar amount. It could be a time period. They all vary slightly. If it comes time for your rent to be paid and the tenant entity doesn't have the money to pay the rent, the worst thing you can do under those circumstances is to get out your personal checkbook and write a check to cover the deficiency without talking to your landlord. Because if you have a cap on your guarantee and you just write that check and you don't talk to the landlord and you don't make it clear that you want that money applied to your guarantee, then at the end of the day, you can write a check for $100,000 in the next few months. And then when the landlord comes and says, when you default because it doesn't work out, and the landlord comes and says, okay, now I'm collecting on my guarantee and it's $500,000. And you say, well, no, but I've already put in $100,000. Legally, that didn't count. And he doesn't have to give you any credit for that. So it's very important to communicate, to let, and you've got the advantage right now, if you do have the ability to write the check personally, the landlord, as we've said repeatedly now, wants you to stay in business. So it is going to be in his best interest to say, yes, please write that check and I will give you credit against your guarantee, because that increases the probability that you're going to be in business 6 months from now and continue to be a tenant for the balance of your lease.
Elizabeth, let me jump in real quickly on that one too, and just anecdotally. So we're having that conversation on behalf of a number of our clients exactly right now, because if your entities are similar to our other clients' entities, is like in an LLC, they don't, you know, they have an entity, it makes money, the money is distributed back out to the shareholders or members of the LLC, and there's no residual capital. They may be keeping in that LLC a few months worth of reserves, you know, to pay bills, assuming that, there's a horrible quote from Tillman Fertitta, but it's sadly true, is most people don't appreciate that yesterday's bills are being paid with tomorrow's income. And the minute you return that money to the LLC from your distribution, that is in fact taking a personal asset and using it to pay your company's bills. And that would qualify as a payment, and Elizabeth's going to correct me if I get this wrong, under your guarantee. And we are getting amendments to our clients' leases when a client is choosing to pay rent for whatever reason, and they are using money coming from anywhere else other than that entity that is the legal tenant to offset against any future claim the landlord has against the guarantee. And it's a fairly easy fix. Hopefully it matters, but it need to be doing that. And again, we're happy to help you. Sorry, Elizabeth, but
that's okay. Yeah. And then the corollary to that is any of these conversations that you have with your landlord need to be in writing and they need to be signed by both parties. Again, every lease out there has a provision that says no amendment is binding unless it's in writing, signed by both parties that it's intended to be enforced against. Emails, while a temporary fix, as Lance was saying back in March when we were coming up, you know, contacting landlords and saying we can't pay April rent, that's fine for a waiver, a temporary waiver of your obligation to pay rent. That does not keep the landlord from then saying that you were in default for not paying. You were in default. You just had an understanding with the landlord that he wasn't going to, or I keep saying he or she wasn't going to enforce their remedies. But if you're actually changing the terms of your lease, for example, as Lance was saying earlier, if one of the common things that people are asking for is to defer April, May, and June, and then amortize that over 2021, if that's possible. That's kind of a good starting point that a lot of people have kind of put on the table, because it buys them enough time for it to be have an actual economic impact to get them through what will hopefully be the majority of this, at least first wave. Most instances, the landlords are not waiving the common area maintenance costs because those are third-party expenses that they're having to pay. So they're having to come out of pocket. That's different from them foregoing rent from you. the point being, though, if you have that kind of an agreement with the landlord, that needs to be in writing and it needs to be signed. Go ahead.
Well, Elizabeth, I was going to say too, the other thing that we're commonly seeing is landlords asking the tenant to provide evidence that they filed for a PPP loan.
Mhm.
And to the extent that loan is granted, that those funds be used to pay rent. The issue that comes up in that is, as I understand the program and our firm has participated in the program, is the loans are based on payroll. And the forgiveness provision is based on payroll. And the fact that you can use that loan to pay rent is a liberty or option that the law provides, but arguably is something that may be recourse to you, because if you don't maintain your payroll notwithstanding, you may have to pay that back. So essentially the landlord is saying it in the context of, well, you're getting the money from the government for free anyway, so give whatever you get to us, notwithstanding the fact that the forgiveness provision may not be applicable to the money you gave to them. And so it sounds really, really good. Well, it's like, well, gee, if I get the money, then I'll give it to you and we'll all be cool about this. And the truth is not so much. And that's one of the things we commonly see offered, and it's coming out of the landlords a lot right now, that and the deferral, and we'll either do that or we'll forget about April, May, and June and add it on to the next 12 months, because you guys are going to be making so much money over the next 12 months, you could be able to catch up on what you owed us from the last 3 months. And the truth is, you may never recover what you lost in the last 3 months. In fact, it may take much longer than a year to get back to where you were. Everyone's circumstances are unique. So anyway, what else, Elizabeth?
Yeah, and to Lance's point, I think it is extremely important to get good advice in terms, when a landlord says that to you, where you're getting a PPP loan, it's permissible to pay rent with a PPP loan, to not jump to the conclusion that that's the correct use of the loan. Because he's very right. Unless you have the ability to maintain your payroll and make that rent payment, you're not going to have the loan forgiven. So again, that's excellent advice on Lance's part. And then whatever is agreed upon needs to be documented. And landlords, and I'm seeing this all over. The landlords say, "Oh no, we don't need to waste that time." Because it doesn't hurt them to not have it documented. You're the tenant's the only one it hurts.
Right.
Or we'd rather keep it loosey-goosey and then be able to say, "Oh, no, you misunderstood. I'm exercising my remedies, keep his options open." You want it documented. The tenant is the one that's gonna be protected by the documentation. Did I see a question? You
did. You'll love the question, because we both know it really well.
What is it?
It's what about the ability to terminate the lease due to impossibility?
Yeah. It's, I would say that right now, that's not an option. Case law can change if this goes on long enough, but under the current case law in Texas, the impossibility of performance is not going to be, it is not going to get you out of a voluntary contractual obligation. And that's what your lease is. So again, things could change as time goes on, but not. Okay, somebody's saying most leases don't have a force majeure clause. In my experience, 99% of the leases that I see do have a force majeure clause. If you don't have a force majeure clause, which you've probably got in the lease, is also a clause called a time is of the essence clause. And a time is of the essence clause says that your obligation to perform is immediate. And so you're really going to have, again, a lease is a voluntary contract entered into at arm's length between two parties. And they generally also say that there was no disparity of bargaining position. So you can't even argue that the landlord tricked you or coerced you. It's a very, very hard road to hoe is what I would say. if there's not a force majeure clause.
Elizabeth, let me go back to the impossibility. And this is, you guys may crack up, particularly those of you who are attorneys on the call. This is where I wander off into your world, is I have read a brief from another firm that about impossibility. And it doesn't go to payment of rent. But what it does go to is to the continuous operation provisions and ability to operate. And it'll be interesting if the law tries to expand that because we can't operate, we don't have an obligation to pay rent. But what I have seen some counsel advise is that a landlord became extremely aggressive and said, you're in default because you're not operating. A defense to the fact I'm not operating would be it's impossible. And I have the citations from it, but like I said, it wasn't a defense to not paying rent, but it was a defense to not being able to operate. You can't make me do something that's impossible to do by government order.
Right, but the question, I believe, was going to termination of the lease.
Right. No, but I did want to expand it that the argument of impossibility. It's actually one of the reasons I wrote one of the questions I did is, does it make it impossible for you to operate your business as you envisioned? And we've nuanced that language in some of our communication with landlords. And it does cause them to pause for a moment. Again, the advice we have is very consistent with what you just provided, is it still is not going to give us an excuse to not pay rent absent a modification to the lease.
I want to have a caveat there, just based on this next question too. Look at your lease, find your force majeure provision, and again, while every lease is different, there is a consistency of concept that has developed. We joke sometimes that we think the landlords have a conference once a year in some secret location and come up with these different ideas that will suddenly permeate every commercial lease that I see that what didn't exist a year ago. So there are concepts that permeate, but look at your force majeure provision and you are most probably going to see a sentence that says, the force majeure provision does not excuse the obligation to pay rent.
And Elizabeth, to affirm what you said, I have the same feeling that no landlords ever get together to come up with a more tenant-friendly lease. I've never had a landlord, and we represent landlords all the time, come up with that. We should revise our lease so it's more friendly to the tenant and excuses obligations that they may have should it not be working out. Landlords can be your friends. I'm a huge fan of relationships, but when the landlord hands you the lease, it wasn't handed to you for the purpose of being helpful. You should assume it's a document that is friendly to them, not you. What's the okay. Can you see the question, Elizabeth?
I don't have a new one. It just saying
Is there, if there's a force majeure clause, we have to pay rent, my landlord's not honoring it, so what's it for? What is force majeure for then? So what good is force majeure? That's actually a great question.
Force majeure is for like your operating covenant. It's for if you were in the middle of your tenant build out and you have a timeline of 180 days that it has to be done, and you can't get materials, you can't get workers, although in Houston, construction is an essential service. It's not everywhere. So then you would be excused of not performing within 180 days because of the circumstances. So it's going to apply to things like that. It just doesn't apply to the payment of rent.
Any other questions? You can't be this good.
Yeah, I mean, reaching out and negotiating with your landlord from the perspective of we're in this together, and what can we agree on that makes us both able to survive this, and taking into account the landlord's circumstances, like Lance said, whether it's an institutional investor or a person who owns one building and this is their source of income, is the way to don't make it adversarial, make it a win-win.
And the other thing I'll share again anecdotally from experience we're currently having, and we're making this up like you guys are having to do at the same time. This is the first time for us to deal with this. Even our friends from New Orleans who had from Katrina their entire community shut down. Once the storm was over, it was over, and everybody went back into recovery mode, and it was just brutal. But it was never like this. But with the landlords we're engaged in right now, and with some of our tenants have not been mindful of the fact. I have a great client has multiple stores, and one of them happens to be a small store downtown. And I've just told my client and the landlord's a major institution who owns a huge office building. The landlord's really just not responding to us because they've got so many other bigger problems than my tenant. And so we've documented, we've tried, we're in default. We know we're in default because we haven't paid April's rent, but we're still choosing not to pay April's rent, recognizing that we've reached out to the landlord, we've talked to a junior property manager, they're aware of the situation. His response was, you and everybody else in the food court, and we'll get back to you. And if it got aggressive, we know that we would have to write a check for rent, and we could do that to stop the process of any kind of collection activity. But we also have a defense of, you told us, and Elizabeth will disagree with me on this because I don't think it's a modification to the lease, but I do think it's some defense. If you told us don't worry about it, I've got an email from you, and so don't go batshit crazy while we're all trying to figure this out. So some of your landlords, if they happen to be big institutions and you happen to be a relatively small tenant, don't be surprised if they don't get right back to you. But document. I mean, that's the best thing you can do. I mean, is that a reasonable middle ground, Elizabeth?
Yeah, that's a reasonable middle ground, but just with the understanding that from an enforceability standpoint, it does have to be in writing and signed.
Yeah.
That just popped up was if they don't want to work with you and you have a personal guarantee, don't make payments out of your own bank account. Just at some point, I mean, if they won't work with you and they're going to terminate your lease and kick you out, then you are no worse off by not, I mean, you got to protect your personal assets. And you can dig yourself a bigger hole if you start paying on the guarantee without getting something in writing from the landlord.
Yeah, and I would encourage you, if you don't have representation, if you have a landlord that is becoming aggressive, whether it's someone in my community or in Elizabeth's community, there's very few landlords we don't know, and we're not seeing that yet.
Yeah.
They would be an outlier, and arguably, and I realize what their legal, I understand the legal context for sure, but they would be a bad actor given the current environment, particularly the fact that I'm going to guess everyone on this call paid March rent, and some of you may have paid April's rent, but having rent be 20 days late is not the reason to go to DEFCON 1. Yeah, and we're seeing the question from Alicia. Alicia, let's talk offline, because that's it'd be interesting to see if that's bluster or that's reality. The question was, they have multiple properties. If y'all can see the questions like we can. Yeah, and we don't expect, we're operating under the concept, look at the question before, I don't know that anyone's expecting to be open in May. There's certainly some friction that we've all seen occurring right now between the business community and our elected officials and the public health folks. And we don't have any expertise in that area, but our firm is operating under the assumption that we will be in this current condition for the next 3 to 5 weeks at least. I, with all my clients, I'm approaching the landlord with that understanding, is we're going to get open as soon as we can. And then the other topic, guys, particularly for those in the retail side of the business, or one of the questions that was posed is, it's not going to return to normal immediately. and rents that you had agreed to pay before may not make sense until it does return to whatever normal is. And even having a longer, more strategic conversation of not only do we need help with not paying April and May's or even June's rent, but we need a rent reduction or some type of other accommodation while our business ramps back up. Like I said, I was watching this poor guy on TV and said, look, if you told me I have to be closed for a month, that'd be fine. You know, I don't mind losing my sales for 100% of a month, but having my entire sales for 6 or 8 or 9 months drop by 20% is the difference between making money and not making money. I can handle one hit. I just can't handle a hit forever and ever and ever. So it is more strategic than just simply, we'll all be okay on July 1st.
Back to the question where the person was talking about that they've already gotten default letters. And I think one thing that would behoove us all to remember is that the landlords have not experienced this either. And so particularly if you have an institutional landlord, I am sure that the very first thing that they did is they called their lawyer and they said, send a default letter to everybody who didn't pay their April rent, because we don't know how this is going to play out and we want to preserve our remedies, because that's just how an institutional landlord thinks. So don't assume that just because you got a default letter, look at who your landlord is and think about why that might have happened, because obviously you're not the only person who didn't pay their rent. So it could have just been, that's our shotgun approach to how this situation is going to be handled to start with. And then that buys the landlord time to start looking at each individual circumstance to determine what to do in those individual circumstances. So I can see, I haven't encountered that a lot, and maybe it's because my clients have representation, and so the landlord knows that there's either a lawyer or a broker involved, and so they're going to go that avenue rather than just the shooting out of a default letter. I noticed that 70% of y'all had someone look at your lease before you signed it, which is an excellent percentage, much, much higher than I would say we would normally run into. So if you have a relationship with a lawyer, I know you don't want to be spending money on legal fees right now, but you know, that bringing them in could solve the problem a lot faster. And I'm not advocating business for your lawyers, but particularly if they negotiate a lease with you and they know that landlord. We were able to get on a lot of the leases that I had done with Lance's firms, we were able to get amendments negotiated within 2 weeks because we all knew each other. The landlords, I knew the landlord's lawyers, they knew me, and we were just able to get it resolved. And it takes you into a kind of a different category.
Well, Elizabeth, we've offered, not to diminish the opportunity for your industry to earn fees, but I've offered to Tammy and anyone else on the call and her membership that if they simply just want to call me and walk me through where they are, I can pretty quickly tell them, hey, we need to engage Elizabeth or one of her peers as you need representation now because this is going south really quickly. Or look, I'm happy to make a phone call on your behalf and see what's up. Yeah, and we've offered to do that. You know, I have, like I said, mixed emotions in that our firm has relationships on both sides. As you know, we do work for both sides. We're hired guns, but typically communication has been efficient, and I haven't run into the situation yet where we've had to escalate. You know that because you've worked with us many times, but I've offered to the folks to provide a buffer to, you don't need to call your attorney yet, or I would get them, let's get them on the phone together. So I
think having a third-party intermediary of some sort, A, gets the landlord's attention, and B, can kind of help, you know, bridge the gap on communication.
And to answer
same thing, just talking to people. I mean, you know, long-term clients I have relationships with, we've just been, you know, holding each other's hands and saying we'll get through this together. So, but yes, and Deborah, to your question, I would, if you want to give anyone my name or Lance's name, would be happy to talk to them and at least point them in the right direction, see what they need.
Yeah, and I would encourage Deborah to your question, if particularly, and my cell number is the worst kept secret. The only thing that's worst kept secret than my cell number is our gate code. But you're welcome to share our cell number. But the best thing you can do is send me an email And if you don't get a response from an email in 24 hours, then call me or text me. But if I get the email, I can kind of see what's up and then hopefully have a more informed, better opinion prior to returning the phone call. And I will call you. We're happy to help. And my heart really goes out for, we're funny. I think of us as a small business. We're actually a pretty good sized firm, and it's affecting our employees personally. We're still paying everybody, but I'm watching just the mental health of some of our folks be impacted, and it's hard. It's really, really hard. It's heartbreaking. So anything we can do to help take a little bit of burden off of you and your peers, we're happy to do that.
That's why we wanted to do this today. We know this is hard on everyone.
Well, with that, we'll wind down the webinar. Lance, Elizabeth, thank you so much for sharing your expertise today. We really, really appreciate it. We know you're incredibly busy, and we thank you for spending the time with us today to help educate our members. And as I mentioned when we started the call, for those of you that weren't able to join us right as we started, the recording and presentation will be sent out. Maureen, if she has not done that yet, we'll be putting the accreditation notice on screen, so you'll see that momentarily. We want to thank the Stonewall Law Association for partnering with us on the CLE. Thank you, Deborah. And Lance and Elizabeth, thank you. They are available if you have questions. Maureen put their contact information in the chat box. If you didn't receive that, we'll include that in the email that goes out as well. I want to thank everybody for joining us. Hang in there. We will get through this. Take care.
Thank you, everyone.
Thank you.